Welcome to the audio reading of Facing Federal Criminal Charges, Why They're Different and How to Win. This is your guide to understanding what makes federal prosecutions so unique and how you can fight back with a strategy built to win. Whether you've received a target letter, been arrested for a federal charge, or are simply under federal investigation, it's critical that you understand what you're up against and how to protect yourself. Chapter 0. Intro. Being investigated or charged with a federal crime can be one of the most terrifying experiences of your life. The stakes are higher, the prosecutors are more aggressive, and the penalties, including long prison sentences, steep fines, and devastating personal consequences, are often far more severe than in state-level cases. At Combs Waterkotte, we understand just how overwhelming this moment feels. And we're here to help you take control of your case and your future. This ebook, Facing Federal Charges, Why They're Different and How to Win, is your guide to understanding what makes federal prosecutions so unique and how you can fight back with a strategy built to win. Whether you've received a target letter, been arrested, or are simply under investigation, it's critical that you understand what you're up against and how to protect yourself. Here's some of what you'll learn. How federal charges are filed. Unlike state cases, most federal charges result from lengthy investigations and grand jury indictments. We explain the process and what to expect at every stage. Why federal prosecutors have the upper hand, and how to push back. The U.S. government has enormous resources and months, if not years, to build their case. You'll learn how a skilled federal defense team can level the playing field. Understanding the stakes. Federal convictions can lead to mandatory minimum sentences, permanent felony records, and even asset forfeiture. We break down the hidden consequences and how to avoid them. Early defense is critical. Whether you've been contacted by federal agents or already indicted, the sooner you involve a federal criminal defense lawyer, the more options you have. We show you how to use the early stages to your advantage. Federal sentencing guidelines and how to navigate them. These complex rules influence nearly every outcome. We explain how your attorney can use mitigating factors and departures to reduce your sentence, or avoid prison entirely. How to beat or lessen federal charges. From challenging search warrants and suppressing evidence to negotiating favorable pleas or taking your case to trial, we outline real strategies that have worked for our clients. Your rights during federal investigation and prosecution. We detail your constitutional protections and how they apply to things like surveillance, questioning, and searches. Choosing the right federal defense attorney. Not every lawyer is equipped for federal court. We provide a checklist to ensure you find experienced, aggressive legal representation that can handle the complexity of your case. At Combs Waterkotte, we've defended clients facing everything from federal drug conspiracy charges and white-collar indictments to weapons offenses, fraud, and internet crimes. Our mission is clear. Challenge the government at every turn, protect your rights, and fight for the best possible outcome, whether that's dismissal, acquittal, or a reduced sentence. This ebook is your starting point. Use it to understand your situation, weigh your options, and take the first step toward reclaiming your future. When you're ready, we're here to help. Chapter 1. How federal criminal cases work. Federal criminal cases follow a very different trajectory from state-level prosecutions, with higher stakes, more powerful prosecutors, and more rigid procedures. If you're facing federal charges, understanding how these cases work isn't just helpful, it's critical to your federal criminal defense attorney building a defense strategy that gives you a fighting chance. How cases end up in federal court. Jurisdiction explained. Not every crime is prosecuted at the federal level. The federal government only has jurisdiction over crimes that violate federal laws, for example, drug trafficking, mail fraud, immigration offenses. Cross state lines, for example, kidnapping, wire fraud, interstate drug conspiracies. Occur on federal property, for example, national parks, federal buildings. Involve federal agencies, for example, FBI, IRS, DEA, ATF. Some crimes can be charged at both the state and federal level, called dual sovereignty. But when the federal government takes the lead, expect a much more thorough and resource-rich prosecution effort. Federal cases are often months or years in the making, and once you're a target, the government will come prepared with evidence, surveillance, and experienced attorneys ready to win. You need your own experienced and skilled lawyer. The Combs-Waterkotte Federal Defense Team provides a comprehensive list of essential resources, as well as the federal crime statutes, 18 U.S. Code, Part 1, Crimes, and 18 U.S. Code, Part 2, Criminal Procedure. The key players in a federal criminal case. Federal cases involve a cast of powerful institutions and individuals, each with specific roles that can heavily influence your future. This include U.S. attorneys, federal prosecutors. U.S. attorneys are elite federal prosecutors who work under the Department of Justice, DOJ. These prosecutors are not overwhelmed like some state counterparts. They are selective, strategic, and relentless. They are typically supported by teams of assistant U.S. attorneys, AUSAs, and often bring airtight indictments to court, backed by extensive investigation. Federal agents. Depending on the nature of the charges, your case may involve federal agencies like the FBI, Federal Bureau of Investigation, DEA, Drug Enforcement Administration, ATF, Bureau of Alcohol, Tobacco, Firearms, and Explosives, ICE, Immigration and Customs Enforcement, IRSCI, Internal Revenue Service, Criminal Investigation Division. These agents investigate the case long before an arrest is made, often using wiretaps, subpoenas, sting operations, and surveillance. Federal judges. Federal judges are appointed for life and have enormous discretion in the courtroom. They oversee your case from pretrial motions through sentencing and are deeply familiar with the federal sentencing guidelines. While they are bound by certain rules, federal judges are powerful decision-makers who can influence bail, trial procedure, and final penalties. Grand juries. Unlike state cases, many federal prosecutions begin with a grand jury, a group of citizens convened to review the evidence in secret. You don't get to defend yourself before the grand jury. Only the prosecution presents evidence. If the grand jury believes there's probable cause, they issue an indictment, officially charging you with a federal crime. The stages of a federal criminal case. Federal criminal cases follow a fairly structured path. Here's an overview of each stage and what it means for your defense. Stage 1. Investigation. This is the longest and most discreet part of the process. You may not even know you're under investigation until it's too late. During this phase, federal agents may use surveillance and wiretaps, subpoenas for financial records or communications, undercover operations or confidential informants, interviews with potential witnesses. If you receive a target letter from the DOJ or an agency contacts you for cooperation, assume you're under investigation and contact a lawyer immediately. Early intervention is often your best opportunity to avoid charges or shape the narrative before indictment. Stage 2. Indictment. If the government believes they have enough evidence, they'll present their case to a federal grand jury. If the grand jury returns a true bill, you are officially indicted. At this point, you may be arrested or summoned for an initial court appearance. The indictment will detail the specific federal laws you're accused of violating. Stage 3. Arraignment. During the arraignment, you are formally informed of the charges and asked to enter a plea, usually not guilty, at this stage. The judge may also decide whether to grant bail or detain you pre-trial. Your defense attorney will begin reviewing discovery, the prosecution's evidence, and may file pretrial motions to suppress evidence, dismiss charges, or request further disclosures. Stage 4. Pretrial and plea negotiations. The government will often try to resolve the case through a plea deal. At this stage, your lawyer evaluates the strength of the evidence. Motions may be filed to suppress illegally obtained evidence. You may be presented with a plea offer. Because the federal government tends to file charges only when it has substantial evidence, plea deals are common. However, skilled federal defense attorneys can often negotiate reduced charges, lower sentences, or pre-indictment resolutions that keep you out of federal prison. Trial. If no plea deal is reached, your case proceeds to trial. In federal court, trials are typically fast-paced and conducted before a jury of 12. Federal prosecutors must prove your guilt beyond a reasonable doubt. Your attorney will challenge the prosecution's evidence, present your defense case, cross-examine government witnesses, argue for acquittal. Federal trials are rare, but winnable with a strategic and aggressive legal team. Stage 6. Sentencing. If you plead guilty or are found guilty, the judge will determine your sentence, often based on the federal sentencing guidelines, which calculate offense levels, enhancements, and criminal history. Your attorney can advocate for downward departures, sentence reductions based on cooperation or mitigating factors, alternatives to prison in some cases. A pre-sentence investigation report, PSR, will be prepared, and your lawyer will argue for leniency based on your background, conduct, and other factors. Key takeaway: understanding how federal criminal cases work is the first step toward protecting yourself. These cases are built differently, prosecuted more aggressively, and sentenced more severely than state crimes. But with a skilled federal legal team and a proactive strategy, you can fight back and win. In the next chapter, we'll dive into why federal charges are fundamentally different from state charges and why that distinction matters more than most people realize. Chapter 2. How federal charges are different from state charges. Most people think a charge is a charge, whether it comes from a local police officer or a federal agent. But the truth is that federal charges are a different beast entirely. They come with steeper consequences, more powerful prosecutors, and fewer opportunities for leniency. If you're facing federal charges, understanding how they differ from state cases is essential to your defense and your future. Here's what sets them apart. Difference number 1. Federal charges are prosecuted by the U.S. government, not the state. In a state case, your opponent is usually a county prosecutor or local district attorney. In a federal case, you're going head-to-head with the United States of America, represented by the U.S. Attorney's Office, a division of the U.S. Department of Justice. Federal prosecutors have close coordination with federal law enforcement, FBI, DEA, ATF, IRS, Homeland Security. Greater resources and investigative tools. More time to build a case before charging. A near unlimited budget, and often decades of experience. State prosecutors might juggle hundreds of cases. Federal prosecutors can afford to focus on a few, and they don't bring charges unless they feel they can win. Difference number 2. Federal law is different, and often harsher. Many crimes can be charged at both the state and federal level, like drug trafficking, firearms offenses, or fraud. But federal statutes often carry longer mandatory sentences and fewer chances for probation or parole. For example, a drug possession charge in state court might be a misdemeanor or probation-eligible felony. That same case, charged federally, could trigger mandatory minimum federal prison time, depending on the substance and quantity involved. Federal sentencing laws are also governed by the U.S. Sentencing Guidelines, which assign points based on the offense level, criminal history, and enhancements, like using a firearm, large-scale fraud, or organized crime involvement. These guidelines limit judicial discretion and often lead to longer sentences than in state courts. Difference number 3. Federal investigations are more thorough and quiet. State law enforcement often reacts to crime. An arrest is made on the spot, and prosecutors build a case afterward. Federal law enforcement flips the script. They investigate first, often for months or years, before anyone is charged. Federal agencies build airtight cases using grand jury subpoenas, confidential informants, wiretaps and surveillance, financial audits, undercover operations. By the time you learn you're under investigation or receive a target letter or indictment, the government may already have hundreds of hours of surveillance, recorded calls, or extensive paper trails. That's why early legal intervention is so important. Difference number 4. Pre-trial release is harder in federal court. In state court, bail is typically set according to a local schedule, and many defendants are released the same day. In federal court, bail, called pre-trial release, is far more restrictive, and you may be detained if you're seen as a flight risk or danger to the community. Federal judges rely on detailed reports and arguments from both sides to decide whether to set a high bond or require collateral, hold you in custody pending trial, release you with conditions, travel restrictions, electronic monitoring. The Bail Reform Act of 1984 gives judges wide authority to deny bail, especially in drug, fraud, firearm, or conspiracy cases. It's crucial that your federal defense attorney prepares aggressively for the detention hearing. Difference number 5. Federal trials move faster, have tighter rules. The federal rules of criminal procedure, along with 18 U.S.C. Part 2, govern every aspect of a case, from discovery to evidence admissibility. Compared to state courts, federal trials move more quickly through pretrial and trial phases, allow less leeway for surprise evidence, have stricter guidelines on what can be argued and how. In addition, federal judges are appointed for life, highly experienced, and often far less flexible when it comes to negotiating or excusing procedural missteps. Difference number 6. There's no federal parole. In state court, even if you're sentenced to 10 years, you might serve just a fraction due to parole eligibility. But under federal law, parole was abolished in 1987. Today, if you're sentenced to federal prison, you serve at least 85% of your sentence, with good behavior. Early release is rare and limited to specific circumstances. Supervised release follows incarceration and includes strict conditions. That means a 10-year sentence usually means at least 8.5 years behind bars. No exceptions, no shortcuts. Difference number 7. Conviction rates are higher in federal court. The stakes are higher, and so are the conviction rates. Over 90% of federal defendants plead guilty, and federal prosecutors have a conviction rate above 95% overall. Why? Because the feds take fewer cases, but more airtight ones. They often have overwhelming evidence. Sentencing guidelines create powerful pressure to plead guilty early. Many federal offenses carry mandatory minimums that make taking the deal feel like the only option. This doesn't mean all federal cases are unwinnable, far from it. But it does mean that your defense strategy must be sharp, informed, and aggressive from day one. Key takeaway: federal charges aren't simply more serious versions of state crimes. They operate under a completely different system with unique laws, stricter procedures, and prosecutors who have the time, tools, and resources to build overwhelming cases. The stakes are higher, the sentences longer, and the margin for error smaller. Winning a federal case starts with understanding the system. Federal charges aren't just higher-level versions of state crimes. They're governed by an entirely different legal system with its own laws, procedures, and players. The government is often steps ahead. If you wait too long or rely on a lawyer who lacks federal experience, you'll be at a serious disadvantage. The good news? Federal prosecutors aren't invincible. With the right federal defense legal team, cases can be dismissed, charges can be reduced, and outcomes can be changed. In the next chapter, we'll explore how to know if you're under federal investigation and what to do immediately if you are. Chapter 3. Signs you're under federal investigation and what to do next. Federal investigations are rarely loud. Unlike state arrests, which often follow immediate evidence of a crime, federal authorities tend to investigate quietly and thoroughly, sometimes for months or years, before making an arrest or filing charges. If you suspect, or even know, that you're being investigated by the federal government, the decisions you make right now are absolutely critical. Early intervention can mean the difference between getting charged and getting ahead of the case. Here's how to recognize the red flags and what to do about them. Red flags. You're under federal investigation. You may not receive a clear notice that you're the subject of a federal case, but there are clear warning signs that federal agents or prosecutors are building something behind the scenes. Red flag number 1. You receive a target letter. A target letter is an official document from the U.S. Attorney's Office informing you that you are the target of a federal grand jury investigation. You may be charged with a federal crime. You have the right to remain silent and to seek legal counsel. If you've received one, it means the government believes it has substantial evidence linking you to criminal activity. At this stage, the indictment is likely coming, but a skilled federal defense attorney may still be able to intervene, negotiate, or prepare a defense before formal charges are filed. Red flag number 2. Federal agents contact you. Agents from the FBI, DEA, ATF, IRS, or Homeland Security might call or show up at your home or workplace, ask you to come in and talk. Say you're not the target, just a witness. Request documents or digital devices. Even if the agents or officers seem polite or informal, do not talk to them without a lawyer present. Anything you say can and will be used against you. These are trained investigators building a case, not friends trying to help. Red flag number 3. You receive a subpoena. Federal subpoenas often come from a grand jury, which is secretly gathering evidence and witness testimony. A subpoena may compel you to testify in front of the grand jury, provide documents, emails, financial records, or data, answer within interrogatories. Getting a subpoena doesn't automatically mean you're a target, but it does mean you're in the government crosshairs. Your federal defense attorney can determine whether you're a target, subject, or witness, and advise on how to respond safely. Red flag number 4. You've been involved in a federal civil case. Sometimes civil cases, such as those involving SEC violations, tax audits, or immigration proceedings, trigger criminal investigations. If your business, finances, or records have come under scrutiny in a federal civil case, the leap to criminal charges is always a possibility. Red flag number 5. Your associates/contacts have been raided or arrested. If business partners, clients, or friends have been served with warrants or arrested by federal agents, and you have any connection to them or their operations, you may be part of a broader investigation. Federal cases often involve conspiracy charges, which allow prosecutors to target people indirectly involved in criminal conduct. What you should do immediately if under federal investigation. If you suspect or know that you're under federal investigation, do not assume it will blow over. The worst thing you can do is wait. Here are the steps to take instead. Step 1. Hire a federal criminal defense attorney immediately. This isn't the time for a general practitioner or a state-only lawyer. You need a federal defense attorney with experience handling cases in U.S. District Court. In the U.S. District Court for the Eastern District of Missouri, St. Louis, the U.S. District for the Western District of Missouri, Kansas City, and the U.S. District Courts for the Southern District of Illinois in East St. Louis and Benton, as well as negotiating with assistant U.S. attorneys and understanding the nuances of grand jury proceedings and federal sentencing. At Combs Waterkotte, we've successfully intervened during investigations, sometimes avoiding charges altogether through early negotiation and presentation of mitigating evidence. Step 2. Do not talk to agents without a lawyer. Even if you're tempted to clear the air or prove your innocence, don't. Federal agents are not obligated to tell you the truth, and they can misrepresent your statements in reports used to justify an indictment. Politely decline and say, quote, "I'm invoking my right to remain silent, and I'd like to speak with my attorney." Step 3. Preserve relevant evidence. Deleting emails, throwing away documents, or wiping devices can trigger obstruction of justice charges, even if you haven't been charged with anything yet. Instead, preserve all communications, files, and records. Your federal defense attorney will help you sort out what's relevant and what's protected by privilege. Step 4. Avoid public comments or social media posts. Do not talk about the investigation online. No vague posts, no jokes, no comments about snitches. Anything you say on social media can and will be used against you, especially in conspiracy or fraud cases where intent and coordination are key issues. Step 5. Stop talking to other people involved. If you and others are under investigation together, avoid discussing the case. Those conversations may be recorded, subpoenaed, or used to establish consciousness of guilt. Even casual texts or calls can hurt your defense later. What a federal criminal defense attorney can do at this stage. A skilled federal defense lawyer can contact prosecutors to clarify your status. Determine if you're a target, subject, or witness. Prepare you for interviews or grand jury testimony. File motions to delay or limit subpoenas. Negotiate for immunity or reduced charges. Present mitigating evidence that discourages an indictment. Early intervention is your best chance at controlling the narrative, influencing decisions before formal charges are filed, and protecting your freedom. The Combs Waterkotte Federal Defense Team has useful resources regarding your case, as well as comprehensive lists of federal crime statutes. Key takeaway: Federal investigations are designed to be quiet, methodical, and overwhelming by the time charges are filed. Acting fast with an experienced federal criminal defense attorney can give you the chance to shape the narrative, protect your rights, and even prevent charges before they're filed. Delay or missteps at this stage can close doors that might never open again. You're being watched or investigated. Get ahead. If you sense something is off, or if you've already received contact from agents or a subpoena, the time to act is now. Federal investigations are complex and unforgiving, but you don't have to face them alone. A proactive, experienced federal legal team can make all the difference. In the next chapter, we'll break down what you need to know about your legal rights, the consequences of federal prosecution, and how missteps early on can have life-altering effects. Chapter 4. Building a winning federal defense strategy. When you're facing federal charges, the government's advantage is clear. They've had time to investigate, coordinate, and prepare before you even knew you were a target. The key to evening the odds and tipping the scales in your favor is a federal defense strategy that's proactive, precise, and relentlessly focused on your best possible outcome. This chapter breaks down the core elements of building a winning federal defense, from the first consultation with your attorney to the final steps in court. Step 1. Hire the right defense team. A single lawyer you find on a bus stop ad can't match the resources of the federal government. No, you need a team of skilled federal criminal defense attorneys. The most effective defenses often rely on a coordinated team that includes lead defense attorneys, an experienced federal criminal lawyer who knows the system inside and out, investigators, professionals with a bevy of resources who can locate witnesses, uncover exculpator evidence, and challenge the prosecution's narrative. Expert witnesses, specialists in forensics, accounting, digital security, medicine, or other relevant fields who can testify on your behalf. Paralegals and support staff, the behind-the-scenes force ensuring every filing, motion, and piece of evidence is handled efficiently. The sooner this team is hired and assembled, the sooner they can get to work, countering the government's head start. Step 2. Master the case. Facts and evidence. Winning in federal court requires knowing the case better than the prosecution does. This means conducting a complete review of all discovery provided by the U.S. Attorney's Office, looking for chain of custody problems in physical evidence, filing motions for additional evidence or to compel disclosure of withheld material, identifying constitutional violations such as unlawful searches or Miranda rights breaches. This phase is not just about reacting, it's about finding the cracks in the government's case and widening them. Step 3. Challenge the government early and often. Federal prosecutors and investigators aren't infallible. Strategic pretrial motions can weaken their case before it ever gets to a jury. Motions in limine, preventing prejudicial or irrelevant evidence from being presented at trial. Motions to dismiss charges. If the evidence is insufficient or the indictment is flawed, charges can sometimes be thrown out entirely. Motions to suppress evidence. Excluding illegally obtained material can gut the prosecution's argument. Early victories in these motions can change the trajectory of the case. Step 4. Build a narrative that resonates. Jurors and judges respond to stories, not just facts. A winning federal criminal defense team frames the case in a way that shows reasonable doubt in the prosecution's version of events, offers credible alternative explanations for key facts, demonstrates government overreach when applicable, highlights your character, background, and motivations. Your federal defense strategy isn't simply about disproving their claims, it's about presenting a compelling reason why justice means not guilty verdict. Step 5. Prepare for multiple outcomes. While acquittal is always the goal, smart federal criminal defense teams plan for every possibility. Negotiated resolutions. In certain cases, a well-negotiated plea deal can avoid the harshest penalties. Trial strategy. When negotiations don't provide the best possible outcome, your case goes to trial. Here, every witness, exhibit, and cross-examination is rehearsed and refined. Sentencing mitigation. If a conviction occurs, presenting mitigating factors can significantly reduce prison time. Planning for contingencies isn't pessimism, it's professionalism. Step 6. Maintain client involvement and control. A federal defense strategy works best when you're part of it. That means providing your federal criminal defense team with complete, truthful information to work with. Staying informed on case progress. Reviewing and approving key decisions. The more invested you are in your defense, and by choosing a federal criminal defense team that keeps you at the forefront, the stronger it becomes. Key takeaway. Beating a federal case isn't about reacting. It's about taking control from the start. The government's head start can be matched and even overcome with a proactive defense strategy that's built by the right federal defense team, grounded in deep investigation, and executed with precision at every stage. From challenging evidence early to crafting a compelling narrative for trial, success in federal court comes from preparation, coordination, and relentless advocacy, long before the jury ever hears your name. How building a winning defense strategy helps your federal case. In federal court, a winning defense is never improvised. It's built with intention, precision, and relentless focus from day one. With the right defense team, the right strategy, and the right preparation, you can challenge the government's case, protect your rights, and fight for your future. In the next chapter, we'll break down common federal defense strategies and how they work, examining real-world tactics used in cases like yours. Chapter 5. Common Federal Defense Strategies and How They Work. Every federal case is unique, but certain defense strategies have consistently proven effective in challenging the government's evidence, questioning its methods, and persuading judges and juries to acquit or reduce charges. This chapter will walk you through some of the most powerful tactics used in federal criminal defense and how they might apply to your case. Challenging the evidence. Federal prosecutors often rely on mountains of evidence gathered by agencies like the FBI, DEA, IRS, or Homeland Security. But quantity doesn't equal quality. How it works. Exclusion of illegally obtained evidence. If federal agents violated the Fourth Amendment during searches or seizures, your attorney can file a motion to suppress that evidence. Chain of custody attacks. Any break in how evidence was collected, stored, or handled can cast doubt on its reliability. Expert analysis. Bringing in independent forensic, accounting, or digital experts to counter the government's findings. Constitutional rights violations. When the government violates your rights, the court may throw out evidence, or the entire case. Examples: Miranda violations. Failure to inform you of your right to remain silent, or to have an attorney present. Due process breaches. Unfair treatment or deprivation of rights under the Fifth Amendment. Speedy trial violations. Excessive delays in bringing your case to court. Lack of intent. In many federal crimes, such as fraud, conspiracy, or certain drug offenses, the prosecution must prove you acted knowingly or willfully. Defense approach. Demonstrate absence of motive or benefit from the alleged conducts. Show that actions were accidental, based on a misunderstanding, or done without awareness of wrongdoing. Entrapment. Federal law enforcement sometimes runs sting operations. If agents induced you to commit a crime you otherwise wouldn't have committed, entrapment may apply. Key points. Your federal criminal defense lawyer must show government agents initiated the idea. You lacked predisposition to commit the crime. Insufficient evidence. The burden of proof is on the prosecution, beyond a reasonable doubt. How it works. Argue that circumstantial evidence is too weak to convict. Show that physical evidence doesn't connect you directly to the crime. Highlight inconsistencies in witness statements. Affirmative defenses. Sometimes the best defense is admitting the act, but proving it was legally justified. Common examples used in federal cases. Self-defense. In violent crime charges, showing you acted to protect yourself or others from imminent harm. Necessity. Committing a lesser crime to prevent greater harm. Duress. Acting under threat of serious injury or death. This defense is based on the notion that there was no other viable option. Negotiated resolutions. While not necessarily a trial strategy, plea negotiations can dramatically reduce exposure in federal cases. Benefits. Lighter charges. Reduced sentencing. Dropping certain counts. A skilled federal criminal defense lawyer uses the strength of your case as leverage in these negotiations. Key takeaway. The strongest federal defenses are built by attacking the government's case from every angle, challenging flawed evidence, exposing constitutional violations, questioning intent, and leveraging legal justifications when applicable. No single tactic fits every case. The key is choosing and combining strategies that exploit the prosecution's weaknesses, protect your rights, and position you for the best possible outcome. Why strategy choice matters in federal criminal defense. Your criminal history, the charges you face, the strength of the prosecution's evidence, the legal precedents in your jurisdiction, the judge and jury pool. The most successful federal criminal defense attorneys often combine multiple strategies, adapting as the case unfolds. In the next chapter, we'll break down the role of negotiation and plea bargains in federal cases, explaining how and when plea deals work, and how to avoid being pressured into a bad one. Chapter 6. The role of negotiation and plea bargains in federal cases. When facing federal criminal charges, most people picture a dramatic trial, arguments in the courtroom, witnesses on the stand, and a verdict read to a tense audience. A la movies To Kill a Mockingbird, A Few Good Men, or even My Cousin Vinny, albeit with a few more laughs. The truth is far different. In the federal system, the majority of cases never make it to trial. Research suggests that only 2 to 3% of federal criminal cases actually make it to trial. Instead, they are resolved through negotiation, most often in the form of plea bargains. A plea bargain isn't just making a deal. It's a carefully calculated strategic move that can significantly alter the outcome of your case. In the hands of a skilled federal criminal defense lawyer, negotiation can mean the difference between decades behind bars and a far more favorable resolution. Why plea bargains are so common in federal cases. Several factors make plea bargains a dominant feature in federal court. High conviction rates for the prosecution. Federal prosecutors win the vast majority of their trials, over 90% by some estimates. This means the risk of losing at trial is extremely high, especially when the government's case is well supported by evidence collected during long, methodical investigations. Mandatory minimum sentences. Many federal offenses carry strict mandatory minimum sentences. Negotiating to reduce the charges or secure a more favorable sentencing range can sometimes avoid these harsh outcomes entirely. The Federal Sentencing Guidelines. Sentencing guidelines in federal court are complex and often rigid. A plea bargain can strategically position you for a lower sentencing range within these guidelines, or even outside them in some cases. The Federal Plea Bargain Process. While each federal case is unique, plea negotiations in the federal system often follow a general structure. Step 1. Evaluation of the case. Your federal criminal defense attorney thoroughly analyzes the evidence, legal issues, and possible defenses. They also assess the strength of the government's case and the potential penalties you face. Step 2. Open or informal discussions. Initial talks with the prosecutor, often an assistant U.S. attorney, may be exploratory, feeling out whether there's room for a resolution that serves both sides. Your federal defense lawyer works on your behalf, but you have the ultimate decision. Step 3. Formal offer. The prosecution may offer reduced charges, dismissal of certain counts, or a recommendation for a lighter sentence in exchange for a guilty plea. Step 4. Counteroffers and negotiation. Your federal criminal defense attorney may propose adjustments to the plea terms, sometimes pushing for sentencing concessions, lesser charges, or the inclusion/exclusion of specific facts in the plea agreement. Step 5. Plea agreement and court approval. Once a deal is reached, it must be presented to and approved by a federal judge. The judge will ensure the plea is voluntary and that you understand the consequences. Pros and cons of a plea bargain in federal cases. Advantages of plea bargains. Reduced charges or counts. Potentially shorter sentence. Avoidance of trial risks and costs. Greater certainty about the outcome. The disadvantages. Accepting a criminal conviction. Waiving your right to a trial. Possible immigration or professional licensing consequences. Why skilled negotiation matters in federal cases. In federal cases, the prosecution has immense resources, investigators, analysts, expert witnesses, and powerful laws in their favor. Without an experienced federal criminal defense attorney who knows how to leverage weaknesses in the government's case and navigate the sentencing guidelines, you risk walking into a plea deal that benefits the prosecution far more than you. A skilled federal criminal defense lawyer will present mitigating factors about your life and conduct, highlight evidentiary flaws to gain leverage, explore cooperation or proffer agreements when appropriate. Ensure the plea terms set you up for the most lenient sentencing possible. Key takeaway: in federal criminal cases, negotiation isn't a sign of weakness. It's a strategic weapon. With conviction rates high and sentencing laws unforgiving, a well-crafted plea bargain can mean the difference between decades in prison and a manageable outcome. The key is having an experienced federal criminal defense attorney who knows how to turn the government's strengths into leverage. Negotiation and plea bargains for your federal case. While some cases must go to trial to achieve justice, the reality of the federal system is that negotiation is often the most strategic path. The right federal criminal defense lawyer will treat a plea bargain as a tactical move, not a surrender, ensuring you emerge from the process with the least damage possible to your freedom, your record, and your future. In the next chapter, we'll break down the federal sentencing guidelines, how they work, why they matter, and how a good federal defense attorney can use them to your advantage. Chapter 7. Understanding Federal Sentencing Guidelines. Once someone is convicted of a federal crime, either by plea deal or trial, the next phase is sentencing. And in federal court, sentencing is not random. It's largely dictated by a strict, complex framework known as the Federal Sentencing Guidelines. These guidelines aren't just numbers on a chart. They are the framework federal judges use to determine how long you could spend in prison, what fines you might face, and what conditions could be placed on your release. While judges have discretion, they must carefully consider the guidelines before handing down a sentence. How the Federal Sentencing Guidelines work. Here are the baseline parts of the guidelines a judge uses to factor a federal sentence. Part 1. Base offense level. Every federal crime is assigned a base offense level, an initial number that corresponds to a starting point for sentencing. Part 2. Specific offense characteristics. The base level can be increased or decreased depending on details of the case. For example, the amount of money involved in a federal fraud case or whether a firearm was used in a federal drug crime can push the level higher. Part 3. Adjustments. Factors such as your role in the offense, leader versus minor participant, obstruction of justice, or acceptance of responsibility can move your offense level up or down. Part 4. Criminal history category. Your prior criminal record is assigned a category 1 to 6, which affects your sentencing range. Someone with no prior record, category 1, will face a lower range than someone with multiple past convictions. Part 5. Sentencing table. By combining your final offense level with your criminal history category, the guidelines produce a recommended sentencing range in months. While these parts might make it seem like your sentence is predetermined, you need a federal criminal defense team on your side to argue for the best possible outcome. Mandatory minimums and statutory maximums in federal sentencing. The guidelines work alongside federal laws that set mandatory minimum sentences for certain crimes, especially drug, firearm, and child exploitation offenses. In these cases, even if the guidelines suggest a lower sentence, the judge must follow the statutory minimum. Similarly, every offense has a statutory maximum sentence that cannot be exceeded, even if the guideline calculation is higher. Departures and variances by federal judges. Federal judges can deviate from the guideline range in certain circumstances. Departures are adjustments allowed by the guidelines themselves, like cooperation with authorities, a minor role in the offense, or diminished capacity. A judge must provide a written explanation for any departure, detailing the reasons for deviating from the guideline range. Variances are sentences outside the guideline range based on broader considerations, such as the defendant's personal history, unusual facts about the case, or other relevant factors under 18 U.S.C. Section 3553A. Like departures, these require the judge to provide a written explanation for the sentence. Why the guidelines matter for your federal defense. Understanding the guidelines is not just about predicting a possible sentence, it's about shaping your federal criminal defense lawyer's strategy. Negotiating charges. Plea bargains can reduce the base offense level, significantly lowering the sentencing range. Challenging enhancements. Your federal defense attorney can contest factors the prosecution uses to increase your offense level. Securing reductions. Early acceptance of responsibility or demonstrating a minor role can shave years off a potential sentence. Key takeaway. The federal sentencing guidelines play a central role in determining penalties after a federal conviction, shaping everything from prison time to fines. While judges have some discretion, these rules, combined with mandatory minimums, set the framework for most sentencing decisions. An experienced federal defense attorney can strategically use the guidelines to reduce offense levels, challenge enhancements, and secure departures or variances, potentially cutting years off a sentence. Federal sentencing guidelines in your defense lawyer's hands. Federal sentencing guidelines are complex, but they are also predictable in the right hands. A knowledgeable federal defense attorney can use this system to your advantage, minimizing exposure, identifying ways to reduce the guideline range, and positioning you for the lowest possible sentence allowed by law. In the next chapter, we'll break down the preparation for a federal trial. Chapter 8. Preparing for federal trial. When facing a federal trial, preparation is not just important. It's the foundation of your defense. Federal court is a high-stakes arena where prosecutors have extensive resources, judges enforce strict procedural rules, and the smallest misstep can change the outcome. This chapter will walk you through what to expect and how to prepare for every phase of the trial process. Federal courts in Missouri, Southern Illinois. There are 2 U.S. District Courts in Missouri. U.S. District Court for the Western District of Missouri. The Western District has 5 divisions. Western Division, Kansas City, includes the counties of Bates, Carroll, Cass, Clay, Henry, Jackson, Johnson, Lafayette, Ray, St. Clair, and Saline. Southwestern Division, Joplin, comprised of the counties of Barton, Barry, Jasper, Lawrence, McDonald, Newton, Stone, and Vernon. Southern Division, Springfield, includes the counties of Cedar, Christian, Dade, Dallas, Douglas, Greene, Howell, Laclede, Oregon, Ozark, Polk, Pulaski, Taney, Texas, Webster, and Wright. St. Joseph Division covers the counties of Andrew, Atchison, Buchanan, Caldwell, Clinton, Davis, DeKalb, Gentry, Grundy, Harrison, Holt, Livingston, Mercer, Nodaway, Platte, Putnam, Sullivan, and Worth. Central Division, Jefferson City, comprised of the counties of Benton, Boone, Callaway, Camden, Cole, Cooper, Hickory, Howard, Miller, Moniteau, Morgan, Osage, and Pettus. U.S. District Court for the Eastern District of Missouri. The Eastern District has 3 divisions. Eastern Division, St. Louis, covers the counties of Crawford, Dent, Franklin, Gasconade, Jefferson, Lincoln, Marys, Phelps, St. Charles, St. Francois, St. Louis, Warren, Washington, and St. Louis City. Northern Division, Hannibal, includes the counties of Adair, Audrain, Chariton, Clark, Knox, Lewis, Lynn, Macon, Marion, Monroe, Montgomery, Pike, Rawls, Randolph, Schuyler, Shelby, and Scotland. Southeastern Division, Cape Girardeau, comprised of the counties of Bollinger, Butler, Cape Girardeau, Carter, Dunklin, Iron, Madison, Mississippi, New Madrid, Pemiscot, Perry, Reynolds, Ripley, St. Genevieve, Scott, Shannon, Stoddard, and Wayne. U.S. District Courts for the Southern District of Illinois. East St. Louis includes the counties of Bond, Calhoun, Clinton, Fayette, Jersey, Madison, Marion, Monroe, Randolph, St. Clair, and Washington. Benton covers the counties of Alexander, Clark, Clay, Crawford, Cumberland, Edwards, Effingham, Franklin, Gallatin, Hamilton, Hardin, Jackson, Jasper, Jefferson, Johnson, Lawrence, Massac, Perry, Pope, Pulaski, Richland, Saline, Union, Wabash, Wayne, White, and Williamson. Understanding the federal trial landscape. Unlike state court, federal trials are meticulously structured and move at a brisk pace once underway. The federal rules of criminal procedure and the federal rules of evidence govern every step, from pretrial motions to the final verdict. Federal prosecutors, U.S. attorneys, tend to be highly experienced, and juries often come from larger, more diverse pools than in state court, making jury selection and case presentation even more strategic. You need a federal criminal defense lawyer who is trial-ready, who has the experience and expertise needed to defend your rights, your freedom, and your future. The phases of a federal trial and how a skilled federal defense lawyer can help. Phase 1. Pretrial. Finalizing your defense. Before trial begins, your federal criminal defense attorney will review and challenge evidence. Every document, statement, and exhibit the prosecution intends to use is scrutinized for admissibility. Refine defense strategy. Based on the government's evidence and witness list, your federal criminal defense attorney will fine-tune your defense strategy, whether that's challenging the credibility of witnesses, undermining forensic evidence, or presenting an alternative narrative. File pretrial motions. Motions to suppress evidence, exclude certain testimony, or dismiss charges altogether can shape the battlefield before trial even starts. Phase 2. Jury selection. Voir dire. The jury will decide your fate, so choosing impartial jurors is critical. Your federal criminal defense attorney will question potential jurors for biases or preconceived notions. Identify those whose professional backgrounds or life experiences could influence their decision-making. Work to seat a jury that will give you the fairest possible hearing and the best possible outcome. Phase 3. Opening statements, setting the stage. The opening statement is your federal defense attorney's chance to outline the defense case, set the tone, and frame the evidence jurors will see. In federal trials, jurors often expect professionalism and precision. Your attorney must engage them immediately with a clear, compelling narrative. Phase 4. Presenting your defense. During trial, your federal criminal defense lawyer may present witnesses, cross-examine the prosecution's witnesses, and introduce physical or documentary evidence. The key goals are: humanize the defendant. Jurors must see you as more than the charges suggest. Expose weaknesses in the government's case. Highlight inconsistencies, questionable motives, or procedural missteps. Undermine the prosecution's burden of proof. Remember, the government must prove every element of the offense beyond a reasonable doubt. Phase 5. Closing arguments, the final push. This is the defense's last opportunity to speak directly to the jury before deliberations. Your federal criminal defense attorney will weave together the evidence, witness testimony, and reasonable doubt to persuade jurors toward a not guilty verdict. Phase 6. Jury, deliberation, and verdict. Once the jury begins deliberating, the outcome is out of your hands. However, your federal defense attorney will remain ready to respond to jury questions, objections to jury instructions, or other developments. If the verdict is unfavorable, post-trial motions or appeals may follow. The importance of mental and emotional preparation in a federal trial. Federal trials are stressful. You may be in court for hours each day over several weeks, listening to witnesses, evidence, and sometimes harsh accusations. Your federal defense attorney will help you prepare for appropriate courtroom apparel, etiquette, and behavior. Understanding your role during proceedings. managing the emotional toll of the process. Key takeaway: winning in federal court begins long before the first witness takes the stand. A successful defense is built on meticulous preparation, strategic jury selection, and a clear, persuasive narrative that challenges the government's case at every turn. With strict rules, experienced prosecutors, and high stakes, your best chance at a favorable verdict comes from working with a trial-ready federal defense team. Preparing for your federal trial with an experienced defense team. Preparation is the difference between reacting to the prosecution's case and actively dismantling it. A knowledgeable federal criminal defense attorney not only knows the law, but also understands the subtleties of persuasion, timing, and courtroom dynamics. With the stakes as high as they are in federal court, meticulous preparation is your best, and often only, path to victory. In the next chapter, we go over understanding the federal appeals process. Chapter 9, Understanding the Appeals Process in Federal Court. A guilty verdict in federal court isn't always the end of the road. The U.S. legal system provides a structured process for challenging a conviction or sentence through an appeal. Understanding how appeals work and what they can and can't do is crucial if you've been convicted in federal court. What is an appeal in federal court? An appeal is not a new trial. Your federal criminal defense attorney doesn't present new witnesses or evidence. Instead, an appellate court reviews the trial record to determine whether legal errors occurred that affected the outcome of your case. The focus is on fairness and the correct application of the law, not re-arguing the facts. Federal appeals courts in Missouri, Illinois. The following are the area's appellate courts. Missouri. U.S. Court of Appeals for the 8th Circuit. Here's appeals from North Dakota, South Dakota, Nebraska, Minnesota, Iowa, Missouri, and Arkansas. Appeal Preparation Info. Illinois. U.S. Court of Appeals for the 7th Circuit. Here's appeals from Wisconsin, Illinois, and Indiana. Appeal Preparation Info. When and how you can appeal a federal decision. Filing a notice of appeal. In federal criminal cases, you have 14 days from the date of judgment to file a notice of appeal. Missing this deadline can cost you your right to appeal. Grounds for appeal. Appeals must be based on legal errors, such as improper jury instructions, evidence admitted in violation of your rights, prosecutorial misconduct, or sentencing errors. Who decides? Appeals in federal criminal cases are heard by a U.S. Court of Appeals for your circuit. A panel of 3 judges will review your case. The federal appeals process step by step. This is the federal appeals process. Step 1. Notice of appeal filed. This short document tells the court you intend to appeal. Step 2. Preparation of the record. The trial transcript, evidence, and filings are assembled for review. Step 3. Written briefs. Your federal defense attorney files an appellate brief arguing the legal errors and how they impacted the verdict or sentence. The prosecution files a response brief. Step 4. Oral arguments. In some cases, attorneys present arguments in person before the appellate judges, who may ask questions to clarify legal points. Step 5. Decision. The appellate court can affirm the conviction, leaving it in place, reverse the conviction, overturning it entirely, remand the case, send it back to the lower court for further proceedings, modify the sentence. What federal appeals can achieve? Not every decision coming from a federal judge qualifies for an appeal. However, if a decision does, this is what an appeal can achieve: overturning a conviction. If the appellate court finds significant legal errors, it can reverse the conviction. Reducing a sentence. Sentencing errors, especially under the U.S. sentencing guidelines, may lead to a reduced sentence. Ordering a new trial. Some cases are remanded for retrial if procedural errors tainted the original trial. Limitations of the appeals process. While an appeal may seem like an appealing idea, particularly given the heftiness of a federal conviction, they do not come easy. Here are some limitations. Appeals are not opportunities to introduce new evidence, except in rare cases. The appellate process can take months or even years. If your conviction is based on strong evidence and no substantial legal errors, an appeal may not succeed. Key takeaway: the appeals process can be a lifeline after a federal conviction, but it's complex, time-sensitive, and focused on legal, not factual, issues. If you believe mistakes were made in your trial, you need an experienced federal attorney on your side immediately. The importance of having a federal appeals specialist. Federal appeals require different skills than trial defense. They demand the ability to identify errors hidden in thousands of pages of records, deep knowledge of appellate procedure, sharp legal writing. The Combs Waterkotte Federal Defense Team works closely with appellate specialists to ensure that no error goes unchallenged and every legal advantage is pursued. In the next chapter, we break down post-conviction options beyond an appeal, such as habeas corpus, sentence reductions, and presidential pardons. Chapter 10. Post-conviction options beyond appeals. Even if your direct appeal is denied, you and your federal criminal defense attorney may still have legal avenues to challenge your conviction or sentence. Federal law provides multiple post-conviction remedies that, if used strategically, can reduce your sentence, overturn your conviction, or restore certain rights. Understanding these options and their strict deadlines is essential to keeping hope alive. The following are possibilities that your federal criminal defense lawyer might pursue. 1. Habeas corpus. Also called a motion to vacate, set aside, or correct sentence, a motion under 28 U.S.C. Section 2255 allows you to challenge your conviction or sentence based on ineffective assistance of counsel. Your lawyer failed to provide competent representation. Constitutional violations, unlawful search and seizure, due process violations, newly discovered evidence that could not have been found earlier. Jurisdictional issues. The court lacked the authority to convict you. This motion must typically be filed within 1 year of your conviction becoming final, although exceptions apply for newly discovered evidence or changes in the law. 2. Compassionate release. Under 18 U.S.C. Section 3582 C.1 AA, you may seek early release if you are elderly and have served most of your sentence, you have a serious medical condition. Other extraordinary and compelling circumstances exist. Recent changes in the law now allow defendants and their federal criminal defense lawyers to file for compassionate release directly with the court, without waiting for the Bureau of Prisons to act, after exhausting administrative remedies. 3. Sentence reduction for substantial assistance. If you provide substantial assistance to the government by helping them investigate or prosecute another person, the prosecution may file a Motion Rule 35B for a sentence reduction. This typically happens within 1 year of sentencing, but late filings can occur if the assistance comes later. 4. Writ of coram nobis. If you have served your sentence but suffer ongoing consequences, such as deportation, loss of voting rights, or career restrictions, your federal defense attorney may be able to file a writ of coram nobis to vacate the conviction based on fundamental errors that weren't raised earlier. 5. Presidential pardon or commutation. While rare, you can apply for executive clemency. Pardon erases the legal consequences of a conviction. Commutation reduces the length of your sentence without erasing the conviction. These are entirely discretionary and typically require demonstrating good conduct, rehabilitation, and compelling personal circumstances. 6. Reentry and collateral relief. Even if your conviction stands, legal assistance can help. Restore certain civil rights. Address immigration consequences. Overcome barriers to employment or housing through certificates of rehabilitation. Seal or expunge eligible records. This is rare. Key takeaway: even after a conviction and the loss of an appeal, you may have options to fight back. Federal post-conviction remedies require speed, precision, and deep legal expertise, making it critical to act quickly and with the right federal defense team by your side. Why you need an experienced federal criminal defense attorney. Post-conviction work is highly specialized. Deadlines are strict, procedural rules are complex, and the burden of proof is often high. A federal defense lawyer familiar with post-conviction litigation can identify overlooked legal errors, navigate overlapping remedies, present your case in the most compelling way, maximize your chances for relief. In the final chapter, we break down life after a federal conviction and a pathway to personal and professional recovery. Chapter 11. Life after federal conviction. Rebuilding and moving forward. A federal conviction can change nearly every aspect of your life, from your personal relationships to your career prospects. While the road ahead may feel uncertain, it's important to remember that your story doesn't end at sentencing. With the right federal legal team in your corner, a little determination, and strategic planning, you can take meaningful steps toward rebuilding your future. Here are the steps to take with your federal criminal defense lawyer after a federal conviction. Step 1. Understand the impact. Before you can move forward, you need a clear understanding of how a federal conviction affects your life. Consequences may include employment barriers due to background checks and professional licensing restrictions, financial strain from fines, restitution, and lost income, loss of civil rights, like voting or firearm ownership, immigration consequences for non-citizens, including deportation or inadmissibility. Acknowledging these challenges is the first step toward addressing them head-on. Step 2. Reentry support and resources. Rebuilding starts with a stable foundation. Many organizations offer programs to help with job training and placement in industries open to individuals with criminal records, housing assistance to overcome rental application challenges, education opportunities, including GED programs, trade certifications, and college courses, counseling and mental health services to support emotional recovery. A skilled federal defense attorney can connect you to trusted reentry programs and help you identify resources in your area. Step 3. Restoring your rights and opportunities. Depending on your federal case, you may be eligible for legal remedies to restore certain rights or mitigate collateral consequences. Your federal criminal defense lawyer can assess your eligibility and guide you through the application process. state-specific rights restoration for voting or professional licensing, certificates of rehabilitation to demonstrate good conduct and improve job prospects, presidential pardon or commutation, expungement or sealing. This is rare. Step 4. Rebuilding your professional life. While finding work after a federal conviction can be difficult, it's far from impossible. Persistence and strategic job searching can open doors that might initially seem closed. Try to focus on industries with few licensing restrictions. Consider self-employment or entrepreneurship to create your own opportunities. Leverage networking and referrals over traditional job applications. Highlight skills, certifications, and any rehabilitation programs you've completed. Step 5. Managing financial recovery. Fines, restitution, and lost income can create long-term financial stress. A few practical steps to take include: work with a financial advisor to rebuild credit. Set up affordable payment plans for fines and any restitution. Seek legal advice on debt management or bankruptcy options if needed. Step 6. Maintain a positive mindset. Perhaps the most important part of rebuilding and moving forward is your mindset. Your federal defense attorney can help you. Surround yourself with supportive people who believe in your potential. Set short and long-term goals to measure progress. Treat setbacks as temporary, not permanent. Celebrate small wins along the way. Key takeaway: while a federal conviction can feel like an ending, it's also the beginning of a new chapter. With a clear plan, the right resources, and a commitment to personal growth, you can rebuild your reputation, restore your opportunities, and create a future defined by resilience, not by your past. Moving forward. Rebuilding after a federal conviction. A federal conviction marks a turning point, not the end of the road. With the right legal guidance, plan, and personal determination, you can rebuild your life, restore your rights, and write the next chapter of your story on your own terms.